for a special permit.
This isn't a special permit.
Well, that's what I said. We don't have a special permit. You don't have to. I mean, look, it's a noble tribe. It doesn't really have to go here. So you don't have to. If you practice it, you don't have to. That's right. That's fine. That's what you're doing.
Oh, with the stuff.
Is it on video? It might be. I don't think it is tonight. They have done. But I have the one thing they have done.
Like to see that. You can set the stage.
But if people have additional more
I don't want to switch for let's start with that. Set the stage. Appeal from You don't have to use it. It's not hard, but they did apply for it. So just set the stage and then tell them to go. Put on the case. No, I understand.
It would be unfair.
This is the zoning board of appeals, April 13th, 2017 meeting. And our attendance is Bob McGrath, Bill Johnson, sorry, Frank Lombardi. This is a continuation of the meeting we opened for the appeal, the cease and desist from SRDP cease and desist order December of 2016. Say that again? Oh, you can't hear me? Yeah, it's on. All right. Is that better? So first we're going to hear from the counsel for SRDP. You want to state your name for the record?
Good evening, Mr. Chairman. My name is Robert Kirsch, and with me is David Gold, and we're here on behalf of SRDP.
Can you speak up, please?
I'll try.
Go ahead.
We would ask that we would like to start the proceeding, if we could, by establishing on the record that the required notices went to the abutting towns, if we could.
Yes. So last Tuesday, the board made a motion to give special notice to the planning boards of the abutting towns. On Wednesday, the notice of the meeting was sent to the 7 abutting towns, the city of Worcester, and the Department of Housing Development in Boston by Federal Express.
Is it possible to list the, excuse me, to list the towns the notice went to for the record?
Do you have a copy of that? Town of Oxford, Town of Dudley, Town of Southbridge, Sturbridge, Town of East Brookfield, Town of Leicester, Spencer.
Okay, and did the town receive written receipts of the service?
Yeah, it was by Federal Express, so we had tracking.
Thank you. The first issue that we'd like to raise is one that I think we raised at the outset of the proceedings, but it is a significant concern to us, and we'd ask that the board excuse Mr. Krieger and his firm from advising the board. And there are several reasons why we think that's very significant. As the board, as members of the board know, Mr. Krieger has already been involved in proceedings relating to the landfill on behalf of other town entities. In that capacity, he has been one of, if not the most aggressive advocate already on the issue that's before the board tonight. So what we're seeking, the only thing that SRDP seeks, is a fair opportunity to present its facts and for this board to listen to the facts and apply the law to them. And our principal concern with Mr. Krieger's participation, and we did point this out as soon as we learned that he would be participating. I think the board's aware, we raised this issue at the outset, is that he's already prejudged the position. And to the extent that he is the one that's advising the board, the procedure that we're likely to receive is going to be biased. Certainly it has the appearance to the public of being a biased proceeding. SRDP is entitled to a fair and unbiased hearing under the state constitution. And there, we've cited the cases in the materials that we presented to the board tonight in the motion that suggest that this kind of a representation in the context of this kind of a hearing could render the proceeding ineffective and objectionable for constitutional grounds. We also think that it's objectionable for statutory grounds. Again, Mr. Krieger is one of the few attorneys in the state who has already taken a position on the validity of the zoning for the basins that we're going to be talking about. While there may be tens of thousands of lawyers in the state, there are only 2 or 3 that we would make this objection to, and we have no personal animus to Mr. Krieger. Personally, he's a professional colleague and friend, but we think that on behalf of SRDP, in order to provide it with a fair and unbiased hearing, he cannot and should not be the one who's advising this board that likely broadcast the kind of the outcome that you're going to have, because he's already taken an issue, he's already taken a substantive position on the sole issue that we care about tonight. So we would ask that the board excuse Mr. Krieger and his colleague from the representation this evening, and we'd like to appreciate a ruling on the motion that we put to the board.
So it is my understanding that it's the town that has engaged Mr. Krieger for our representation, and so it's not, the board hasn't voted whether to engage him or to seize him. I don't think we have the authority to do so. We have spoken to him about the issue when you raised it, and they advised us to move forward. As a matter of, I can certainly note that in the record, but at this point, we're not going to excuse him. I don't even think we have the authority to excuse him at this point. And we haven't had any substantive conversations, to my knowledge, with him about anything at all other than procedural points up to this point. So, your motion is duly noted, but we're still going to move forward with Attorney Krieger as counsel.
With all due respect, Mr. Chairman, procedural aspects of a case like this are quite important. And I think you know as an attorney that procedural issues in a hearing can be determinative of the outcome. And that is one of the things that we're concerned about here. We're not asking, if you are telling us that it is outside of the authority of this board to dismiss Mr. Krieger, we're not asking that you dismiss him. We're saying that if the board consults with him in this case, which is certainly within your purview, no one's compelling the board to confide in Mr. Krieger or to seek his guidance, because we know what his position is on the ultimate issue. We've seen that, he's written about it, it's a public record. What we're asking is that you not consult with him. That's certainly within your purview. You don't need to consult him. There's no other way to put it, but when he's the one advising you on how to rule on our motion about whether he ought to be disqualified or not, or he ought to not be with you you can imagine the appearance that that creates and the concern that we have trying to seek a fair hearing on this matter.
Yeah, but up until this point, any attorney that advises us in terms of the matters of procedure, I agree that it's important, but there hasn't been any conversation at all about any substantive matters that I think that would bias the board members in any way. I don't even think that he's had conversations with any board members, other than maybe hello and, hi, I'm Arthur Krieger. So, Attorney Krieger, if you want to, I see you standing, if you want to make a comment, that's fine.
Thank you, Mr. Chairman. Art Krieger from Anderson and Krieger in Boston. I was hired as special town counsel for the various matters regarding the SRDP landfill to advise any town boards who might need my advice. I wrote a letter that Mr. Kirsch has attached to his materials to DEP regarding the landfill expansion. I did that on behalf of the Board of Health and the Board of Selectmen. And the other half of my engagement so far has been to advise the zoning board on this appeal. I had no role in the issuance of the cease and desist order. There was the independent judgment of the acting zoning enforcement officer. And my letter to DEP was before SRDP appealed that cease and desist order. So the state of the record, the state of the law, as I saw it when I wrote to DEP, was that the landfill basins had been declared to be in violation of zoning. It is not accurate to say that my mind is made up or that I have prejudged the issue now that SRDP has appealed it and is about to put on an extensive presentation. I will advise the board objectively, I will advise it fairly, and the board is free to take or reject my advice as any client is. So my view is that there's no basis whatsoever to question my impartiality or these proceedings based on the letter that I wrote for the other town boards where I'm special town counsel to the various boards. And I put up, just as Mr. Kerr said, he raised this issue back in January. I responded to it in writing in January, and that response is also in the packet of materials that he either has submitted or I think intends to submit. My advice is to proceed. This has been delayed a long time for procedural reasons, and I think we should get on with the hearing.
Frank, is this Mr. Kirsch bringing this subject up once again? Is this the first notice that this board has heard of this complaint on the part of the plaintiff here?
What you mean of?
I mean, he's bringing this up.
Attorney Krieger's representation of the town?
No, just what he's saying to us tonight.
That we should excuse?
Yeah, I mean, is this the first time you've heard of it?
No.
Well, it's the first time I've heard of it.
There was a letter sent at the beginning of the year that Attorney Krieger responded to.
I see. And now he's bringing it up again.
Yes.
Was he answered properly on this letter at that point?
Attorney Krieger responded to Attorney Kirsch's objection in January.
Okay, and you got a copy of that?
I believe
So that
so.
we could, so this board would know how we felt about it.
Yeah, and my feeling is that, Attorney Krieger may have, like he said, is that he could offer us advice
Sure.
and counsel,
Right.
but it is up to the board members to make their own decision.
That's
And they
correct.
can either accept or reject what he has to say.
Well, I just will say this and shoot the first shot over the bow. This is just another excuse to delay the process, in my opinion.
So, I certainly, Attorney Kirsch, certainly note your concern and objection, but I think the board would still like to proceed at this point, and we're going to retain, we're not going to have Attorney Krieger excused at this point. I think that he may have his opinion, but the board can also have their own opinion. They don't necessarily need to, whatever he has written in the past, they can certainly make up their own decision on whether or not, all the facts that come out tonight in the next couple of meetings.
I would just ask the board to consider how this looks in an objective setting, how it's going to appear to a public that looks at the proceeding when the board is taking advice from someone who's already taken a clear substantive position on the sole issue that's before us, and an issue that we're supposed to get an open and a new and a fair hearing on.
And that's what you're gonna get. I haven't, regardless of what Attorney Krieger's opinion is, I haven't made up my decision until you know, what you have for your evidence to come out and anybody else. And if the other board members wanna,
I'm just wondering, is this a legal opinion, or is he just worried that we're going to be steered in a direction that Mr. Krieger is going to?
Yes.
Is that the only thing? It's not a legal complication, is it?
I'm not sure that I understand it. We do think we've objected on legal basis. We've cited to the state constitution and to a state
Well, this is
statute.
your interpretation of it.
That's all I've got.
Okay, so let's proceed.
you wanna make a motion? Someone wanna make a motion whether we're gonna excuse or proceed?
I've made a motion. Filed a motion.
Okay.
We'd appreciate a ruling on it.
So, they made a motion that they had asked us to excuse Attorney Krieger from proceeding. Does someone want to excuse Attorney Krieger from the proceeding? All in favor of excusing him, say aye. All in favor of going forward with the procedure with the same counsel, aye.
Aye.
You've got the vote on the board, Counselor.
I would ask that the board allow us to suspend so that we can take the question to a judge and get a ruling. We think that this is a very serious legal matter.
You know, my feeling is that if depending on how the board votes, if it's a matter that you want to bring to court at some point after our decision in appeal, that's certainly your case, but we'd still like to proceed tonight.
I guess I'm asking that the board suspend so that we can go. And I guess if the position is that the board will not suspend, I'd like that to be on the record with a vote so that we know what our rights are.
Absolutely. The applicant has asked if we could suspend pending their application of a hearing with a court of competent jurisdiction. We want to have a vote whether or not we want to suspend this hearing or not. All in favor of suspending, say aye. All in favor of moving forward, say aye. Aye. The board carries it, Counselor.
Thank you, Mr. Chairman. So we're here tonight to review our appeal of the zoning enforcement officer's position. And I will confess that I anticipated before I started speaking that the zoning enforcement officer would have laid out the actions that we've taken and the reason that we're here. But I'm happy to start, and then we can take the lead. We're talking about basins that were developed, they're located near the landfill, and we're going to present to the board testimony from witnesses that will establish that essentially basins are basins. There's no, the fact that these basins happen to be located near a landfill does not mean that the basins are part of the landfill. In fact, and what you'll hear tonight is that there would be basins built if there was a school building in the nearby property. There'd be basins built if there was a McDonald's on the nearby property. There'd be basins built if there was a hospital on the nearby property. That there is no issue associated with the landfill, and that in fact various aspects of the letter that were written by the alternative zoning enforcement officer, the letter which constitutes the cease and desist order, are simply wrong as a factual matter and wrong as a legal matter. The basins are developed, in this instance, exclusively for the protection of the environment. And what you'll hear tonight is that those basins have environmentally sound reasons behind them, that they allow for nearby wetlands. A wetlands, I should add, that is located in the town of Charlton to be protected and to be sustained and to be maintained. And that the basins are what allow the water to flow from the nearby areas, in one instance, a soil stockpile, and in another instance, surface drainage on top of the landfill. That water flows into these basins. But indeed, it's true that the land, some of the land from which the water flows is located in Southbridge. The water does flow into Charlton. All the water that flows to Charlton would flow there regardless of whether the landfill existed. And in fact, you'll hear testimony to the effect that the amount of water that now flows into the basin, is particularly the basin that accepts water from the surface of the landfill, actually has a smaller flow than would be the case if the landfill weren't there. So while there is flow, and it is natural flow, that flow is less than it would be without the landfill. All of these basins were built following established legal proceedings. They were open, they were public. You'll hear the basins involve judicial settlements in some instances. In every instance applicable, SRDP went before the Conservation Commission of the town in an open process and gained the approval of the Conservation Commission in the course of constructing these basins. I'm going to refer to the basins as Z3 and Z4, and we'll be putting diagrams up and we'll explain to the board what they look like. They are each generic tools. Neither of them has anything that's specific to a landfill, and the statements in the cease and desist order to the effect that these are related to the landfill or involve landfill activities or somehow are associated with trash is wrong. Those are mistakes. And the point that I want the board to take away from the fact that in both instances, we're talking about the effects of gravity and precipitation, so that it's natural conditions that lead to the flow of water here. What we're talking about tonight is essentially the regulation of natural surface water flow. So while the water may flow through conduits and route to where it gets in these basins, the water would reach these areas in any event. So what we're essentially dealing with tonight is a zoning enforcement letter, a cease and desist letter, that essentially seeks to use the zoning bylaws of the town of Charlton to regulate natural surface water flow. And I would submit to you that there is no basis for that in Massachusetts law. There simply isn't a basis to go out and control surface water flow that would naturally be occurring. And that's what's being done here. And that's simply wrong as a legal matter. The factors that I'm going to review now are ones that a court would consider, because I think it's important that the board keep in mind what will happen in this case in light of an adverse decision by the board. We fully hope and expect that when you hear the evidence and understand what's really at issue here, that this board will find that there is no violation of the zoning ordinance, either because there is no basis or that the basins themselves are not inconsistent and not in violation of the town zoning ordinances. The first issue that the court is going to look at, or among the issues that the court will look at, is whether the basins were developed in good faith. And as I've said, they were done through open legal proceedings. In many instances, they were done at the behest of either a judicial order or in the face of an enforcement agreement. There's in no instance was any of this done either by subterfuge or in the dark of night. This was all done in the open, following wetlands regulations and procedures, with the approval and oversight of the Department of Environmental Protection. And we'll talk more about this later, but You can't simply take away a basin where groundwater flows. And there are a couple of reasons that that's going to be an issue here. Number one, the Department of Environmental Protection would have to approve and be part of any kind of action like that. You simply can't do it. And number two, anything that's done here would have to, keep in mind the protection of the wetlands. And if you do anything to upset these basins, you're going to dry up the wetlands. And essentially, the state won't allow us to do that. The state won't allow you to do that. You can't take that water and send it somewhere else. You're going to dry up the wetlands, you're going to damage things. These basins are essentially constructed and maintained to protect the environment. They're there to stop water from flowing faster. They're there to stop water from coming down at a rate where it could cause damage, could cause erosion, could cause sediment to build up, all invaluable wetland resources. So anything that you do along those lines that try to disrupt that would cause environmental harm in the town. Another factor that courts are going to look at if the board were to rule against our appeal is what kind of harm the company would suffer. And there'd be a pretty serious harm here because, of course, SRDP can't make the rain stop. And these basins are there because it rains. They're not there because of any other activity. They have nothing to do with trash. They have nothing to do with waste handling. They have nothing to do with waste disposal. We can't stop stormwater from flowing in the direction in which it naturally flows. And what you do is these basins are in the direction of natural stormwater flow. So anything that you did to try to stop that would be imposing an unreasonable burden on SRDP to interrupt natural surface water flow in Massachusetts. We could not, as I pointed out a few minutes ago, be asked to take a step that would de-water the wetlands. We simply can't do it. There's been a lot of work done in conjunction with developing and maintaining this landfill. The state in particular has been at pains to make sure that all of the operations in the area and any activity protects wetlands. I'm sure that this board is familiar with wetlands protection both at the town and at the state level. And anything that we've done to disrupt the surface water flow would have an immediate and potentially devastating effect on those wetlands. If we were asked to do something to stop using these basins or to take the basins away, that would be in violation of state and federal stormwater management regulations. So there's a state and federal overlay. These areas are already regulated elsewhere, and essentially we wouldn't be able, under your authority, to simply take the basins away. It would violate state law and it would violate federal law. We can't do that, and we don't think that you want to do that. And in addition, you'll see that there are court orders that are involved in the construction of the basins. So that to undo the basins, which were put in place pursuant to court orders, would require probably judicial relief, because we can't go and violate court orders, and we don't think that the board wants to be in the business of ordering us to violate a court order, or to take it upon itself to take an action that would be in violation of a court order. So that's the second factor. Each of those reasons falls into the second factor that the court would look to on appeal. So whether there's going to be a harm to this party, to the appellant. The third factor that the court is going to look to is the fact that municipal officials were actually involved in the construction of these basins. And I've already alluded to that. There were open and notorious public proceedings. There were filings with the Conservation Commission. There were notice to boards of the town. One of these basins was put in 2005. That basin has already been in place for more than 10 years. We're more than 10 years out. There's actually a legal basis to not challenge that. It's a statute of limitations issue, something that was already in place 10 years ago pursuant to a court order. And you'll find that in both instances, excuse me, you'll find that there are orders that were issued, or orders of conditions that were issued by the Conservation Commission of this town relating to these basins. So this is, again, this is something that was done openly, it was done under the law, it was done in good faith. All factors that are open to. The fourth factor that a court would consider, and the court need not consider all these, but I'm going through these factors because I want the board to understand that we believe that on each of these factors, the weight of the evidence stacks up heavily in favor of SRDP. It acted in good faith, it did what it was supposed to do, it complied with the law, complied with court orders. It acted consistently with the regulations of this town. So we want you to understand, I'm walking through this, I realize it's a little painstaking, and I apologize for that. But this is what the court is going to look at. If the board doesn't rule in our favor, we understand that there's some public pressure, we feel the weight of what's on this board, and that is the reason that we're trying to protect our rights to an unbiased hearing tonight. We want you to understand what a court would do and where a court would go if the board doesn't rule in favor of the appellant. The fourth factor that the court would look at is whether the party who brought the enforcement proceeding initiated the action before the basins were developed, and whether it sought an injunction. And here, of course, there was no such action. These basins went in, they went in according to public proceedings, and the Clean Wells group that asked the zoning enforcement officer to act waited, in one instance, more than a decade, in another instance, more than 2 or 3 years before taking any kind of action. It certainly could have acted long before then if there was a concern. Excuse me. There was no effort to hide what went on here. This was all very publicly done. The fifth factor that the courts will look at is whether there's any kind of injury to the group that instigated the action. And in this instance, we believe it might look to Mr. Jordan and Clean Wells. And in fact, what that examination by the court would show is that this is not really any kind of an action seeking to address any kind of injury caused by the basins, and that the basins are simply being used as a vehicle to attack the operation of the landfill. I mean, that's clear from looking at the website of the Clean Wells group. It's clear from looking at the kind of public discourse that's taking place online about these proceedings, that this is really a collateral attack on the operation of the landfill. So the court will look at that and see that this is not really an attack that's legitimate because it's concerned about land use and about the existence of the basins. The sixth factor that a court would look to is whether the proceeding was brought in a timely manner. And again, in the instance of one basin, the basin's been in place since 2005, the other since 2014 or 15. These basins have been around for years. This could have been challenged in the course of the permitting process. It could have been challenged in the judicial proceedings when the settlement was, when the enforcement order was issued that required the basins to be constructed. There were many, many opportunities when this could have been done, but it wasn't. The parties waited and waited for years before bringing this action. And that's because there is not a legitimate injury. Yes?
I got a question. You referred to a settlement issue. The reason why the basin was put in, is that correct?
No, I misspoke. There was I caught myself using the word settlement.
Okay, because normally that would be a reason for that catch basin to be put in, correct?
Normally, I'm not sure, but these basins were put in pursuant to enforcement orders. It's clear in the record. You'll see the documents that we're submitting to you. It's very clear why these basins were put in. I'm not sure if that answers your question.
Well, just normally when you have like stormwater runoff, something like that, you have a certain type of soil that runs off, and you'll have sediment built up. Normally, if you have an issue like that, DEP will get involved, and they might put in basins or change it. So that's why when you said that, you automatically brought it up in my mind. So that's why.
Well, one of the documents that you'll see is in fact an enforcement order that resolves a compliance issue. That's the older basin. Keep in mind that SRDP came in as a subsequent operator of the facility. When it came in, the wetlands were kind of a mess. And one of the things that it did was work with the Attorney General's office and work with the Department of Environmental Protection to identify the steps that it would take when it became the operator to address the conditions so that the landfill could be run in an environmentally sound and protected way. And part of that was to protect the wetlands and the wetlands in Charlton in particular. And one of the things that was ordered by judicial settlement entered into with the Attorney General's office. I use the word settlement, but you'll see that a judge signed it. So it's not as if parties can decide this they are or aren't going to do. It was mandatory, was to construct a basin, and in fact, to construct one of the basins that this board is now considering as to whether it's in compliance with the zoning. Does that answer your question?
Yes.
Another question that a court will look at is whether the existence of the basin, the basins in this instance, runs afoul of the agricultural zoning district. You know, is there an issue with having a basin that collects water that's somehow inconsistent with the agricultural zoning? And I think the board is aware that the whole issue here, the reason for the attack by the Clean Wells Group and Mr. Jordan, has nothing to do really with the agricultural use and whether or not a basin is inconsistent with an agricultural use. It's because of an objection to the existence of a landfill that's properly zoned in an adjoining town. And we think that's going to be a factor that the court would look at, along with the fact that these basins, in fact, protect the environment, they protect the agricultural nature of the land because they preserve the soil, they stop erosion, they prevent the deterioration of the wetlands in Charlton that are going to be important to preserving and continuing to have an opportunity for agricultural use and agricultural development. And you'll also hear evidence, of course, and this is probably something that's very well known to this board, that when Charlton created the agricultural district back in 1987, I believe, there already was a landfill within it. And there was the town landfill was in fact open and operating and within an agricultural district. So even to the extent that that was a legitimate question here, it seems that the town's already addressed it by establishing zoning and not doing any kind of carve out, allowing the landfill to go on and to continue operating without any question within an agricultural district. Another question that will come before the court, and which the court will consider in evaluating how to move in an appeal should it become necessary, is whether Charlton seeks to have us remove or destroy the basins. We don't know what kind of relief the board would consider were it to support or uphold the decision of the zoning enforcement officer, but clearly, I think I've explained our position that if you change those basins, there's going to be an immediate and material damage to the local environment. So in the event that a court found that there was a zoning issue here, it would still look to whether there was a less invasive means of mitigating any kind of zoning harm. So even if you would assume that we would lose, and I'm hoping that the board, in hearing what the actual facts and the law are, and the evidence that's going to be presented to you tonight, will realize that there isn't a zoning enforcement issue here, that there isn't a basis under either the town's zoning bylaws or in fact state zoning law to regulate natural surface water flow in Massachusetts. There's no legal basis to do that. That there would be a means short of closing the basins, short of shutting them down or filling them in, to address any kind of a zoning defect with the board to find areas, and that could certainly be done through the grant of variance. And then the court would look at whether there were monetary damages involved or being sought. But in fact, there's no cognizable harm, no claim of any kind of financial harm with the existence of these basins. That's in part because zoning and land use was not really the use behind the attack. It was not really the purpose behind it. This was really part of a collateral attack on the operation and existence of the landfill. And there isn't any encroachment onto anyone else's property. And certainly you're aware that in most instances, when this board is overseeing appeals, you're looking at the effects of what one property owner might wish to do that could have a damaging impact on another property owner. That's not the case. In fact, the use of these basins, the existence of the basins, the function of the basins, all endures to the benefit of the land. It endures to the benefit of the environment. It endures to the purpose of the agricultural district that the town put into place in its zoning. And without these basins, the natural water flow would be faster. The natural water flow would be more harmful to the environment. The natural water flow would be more damaging. Because certainly we would not expect that in any instance that this board would attempt to require SRDP to change the natural flow of water. And what you will hear tonight is that the natural flow of surface water is into these basins. Now you're also going to hear some details about the kind of water that is in these basins. And it is precipitation. It has nothing to do with landfill activities. It has nothing to do with waste disposal. It has nothing to do with the transportation of waste. In one instance, one of the basins doesn't even have anything to do with the landfill. It does receive precipitation that falls on a pile of soil. The soil at some point may or may not be put onto the landfill, but it is just that. It is dirt, it is soil, it is organic material. It has nothing to do with the landfill. The letter of the zoning enforcement officer is simply wrong on that fact. And we will also show you that the letter of the zoning enforcement officer was wrong to the effect that he believed that there was waste involved, or any kind of waste disposal activities. So, let me preview a little bit of the evidence, and then I think we can get into it. Perhaps we can hear from some of the witnesses and let the board ask questions. I think that would be the most helpful thing. But the letter issued by the zoning enforcement officer is based on factual errors. Mr. Leonardo simply wasn't familiar with landfills. He wasn't familiar with these basins. We're not aware of him having asked any questions of anyone who was familiar with them when he went out to do his inspection, to the extent he did conduct an inspection. But you'll hear from Tracy Markham that the basin that we're going to call number Z4 receives stormwater from a soil stockpile. That's the one that I've told you about. I think this board may be aware of circumstances that developed there a couple of years ago. There was a problem with that soil stockpile that's been addressed. Those problems were addressed in part because of the importance of the wetlands that we've talked about, and the integrity of the basin that we're here to talk about tonight was very, very important to protecting those wetlands. That was a proceeding that the town, through its Conservation Commission in particular, participated in very, very closely. You'll also hear about Basin Z3. That basin receives stormwater runoff. It does not receive leachate. To the extent that the zoning enforcement officer's letter suggests that it receives leachate being the liquid that may in fact touch the waste of the landfill, he was wrong. It's just not possible for that to happen. That was a factual error in his understanding, and it's a defect in the cease and desist letter.
Sir, will you answer the question why it's not possible in your presentation?
I don't know if I will, but I would invite you to ask it of Ms. Marco or Mr. Poirier when they're up testifying. We have people here who can answer your questions, who understand the legal landscape works, and we would encourage you to ask your questions. So Basin Z4 is associated with the stock. Yes, sir.
Excuse me. We have the aerial photo of Basin Z3, but in what was presented to me anyway, Z4 is not here.
I think it's up on the corner, up on the corner. Nothing here? It's in yellow, Bob.
It says West Basin, is that what you mean?
Mr. Chairman, can I suggest that if the board members are looking at documents or discussing documents, that you identify them for the record? I don't know if you want to have a number list of exhibits that Ms. Gale can maintain, but I think it would be good to have the record clear what everybody's looking at.
Well, you mentioned both of them as, you know, Z3. I understand that because I have a picture of it. But Z4, I do not have any information on that.
So, for the record, in your appeal application, it was included a overhead photograph of the basins in question. That's what you're looking at, right?
Correct.
Well,
Yeah.
this one only shows Basin Z3.
The West Basin
We put up on the screen right now, this is under SRDP number 2, and it shows the West Basin.
Right, the West Basin is Z4.
If the board would like the reminders to have each of these exhibits in it, then you would be able to follow along.
What you're referring to is Basin Z4, is the West Basin in the topographic photo.
Correct.
So maybe we just pause for a moment on the record. Can I speak to you without the phone, or we can get a moment?
Say that again?
Can I speak to you here just about the documents? Let me heard.
Yeah, why don't you go to
So SRDP has provided boxes of documents that's labeled Board 1 of 2, Board 2 of 2, and Extra. Each of the boxes, I believe, has half a dozen or so identical binders of hearing exhibits. I don't know if what you're looking at is in the binders. I assume it is somewhere, but it would be useful maybe to pass out the binders and be able to identify what everybody's looking at and asking questions from. If you have any other questions, you're free to ask them, but I think it will be more orderly if people have the binders in front of them, and SRDP should identify whatever it's referring to. So if you agree with that, Mr. Chairman, I'll pass up the binders.
I agree with that. We'll have to make a motion to accept the binders into the public record. Say that a little bit louder.
I make a motion to accept the binders that SRDP has provided into the public record.
Is there a second?
One second.
Thank you.
Alderman Graf, seconds. All in favor, say aye. Aye.
If I wasn't here, what would you have done?
I don't know.
Okay. You should have the official.
Give me a multiple choice test on this.
Mr. Search, are the extras available for anyone to watch on it in the audience, or did you have them in mind for witnesses, or what?
We made them available for the board to distribute as it seems proper.
How many extras are there?
We brought 20.
There's a lot of those in line.
You want to just make them available for anyone who wants to take a look at them, as long as they're available.
We will be attempting to project exhibits up when we discuss them, but it may be easier for people to also see the exhibits in the binders.
Can somebody point out the fact where D4 is in this? D4. I mean, Z4.
That's found at exhibit that's labeled SRDP2.
Is everyone okay? You want to continue? Are you ready to continue?
Unless there are questions, yeah, I was just pausing to answer questions. Yes, we will continue.
Okay. Is there any questions? Is there any questions?
So again, I'll be speaking about, and you will hear testimony on this. This is really just my summary so that the board will understand what's coming. I think you can listen now, but there'll be more than adequate opportunity when the witnesses are speaking to actually look at the exhibits and understand the testimony and understand the facts. So you'll hear from Tracy Markham. She'll talk about both of the basins. As I said, you'll learn the basin Z4 has nothing to do with the landfill at all. The water that reaches Z4 comes from a soil pile. Nothing to do with waste. And the basin Z3 does receive runoff that's from the top of the landfill, but it does not receive leachate. And I think you'll be able to question here, it cannot receive leachate. The systems are running separately. It's not used for the treatment of waste. Basin Z3 is not used to store waste. It has nothing to do with the disposal of refuse. And for purposes of the board, it doesn't have anything to do, it's not part of the landfill. It simply isn't. It's, when you look at how the landfill is defined under state law, that basin is not part of the landfill. And the ruling suggesting that it was would be legally wrong. You're also going to hear from Mr. Poirier. Matt Poirier is a civil engineer. He's also a registered professional engineer in Massachusetts and in several other New England jurisdictions.